Good morning, sir.
Good morning.
I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state. Prior to coming in this morning, had you heard anything about this case?
No, I have not.
Now, you heard that the trial is anticipated to be 2 to 3 weeks, so we believe that will be done 2 weeks from 2 weeks after this week. Do you have any extreme hardship or anything that will cause you to be unable to sit for the next few weeks?
Yes, would you like to I'll tell you what my occupation is. If you'd like to know, I'm the chief academic officer for the school district of Lee County.
Okay.
I bring in all the principals, assistant principals tomorrow, Friday, and Monday. It's my meeting with them. We have national speakers that are coming in, and that is our annual once-a-year meeting where we debrief about everything that transpired this past year and what's coming up for the next year. So that would cause me to move all those meetings somewhere else.
Okay.
Not that it couldn't be done. I'm just letting you know that would be the hardship.
Sure. And is that I assume that's a really big deal as teachers have vacations planned down the road and there's only a certain limited time you can get these meetings in. You have a hard time paying attention or focusing on this case, knowing that you would have to do something like that?
It's my meeting. That's the chief. Those are my people that underneath me. So it'll be my meeting. And yes, it would be a struggle for me to not be able to concentrate on what I should be doing as opposed to being here and giving my full attention here.
Thank you very much.
Thank you.
Good luck with your votes.
I have no questions.
All right. Sir, your jury service for the year is complete, and thank you for your service. You're excused.
Thank you.
Any objections to 192 being stricken for cause?
No.
379.
It's a higher percentage than we've had the last 2 days.
Yeah.
Your entry.
All right, please be seated. Are you juror 379?
Yes, sir.
Then I'll allow the attorneys to begin their inquiry.
Good morning.
Good morning.
I'm Sarah Miller. This is Andreas Gardner, and we are both here on behalf of the state of Florida. Prior to coming in this morning, had you heard anything about this case?
Only on watching a couple of news programs, just having it on and seeing it on there.
Right. Now, the state will be obligated to prove the charges beyond a reasonable doubt during the guilt phase with evidence only in this courtroom. We'll be calling witnesses, presenting photographs, and other various forms of evidence that the jurors will be asked to consider in reaching their verdict. We can't control what the news says or what happens, which is why it's really important that you only consider the evidence. Do you believe you'd be able to set aside anything you may have heard or read prior to coming into court and decide this case solely on the evidence?
Yes.
And then as far as the time length, we believe it'll be another 2 weeks beyond this week. Do you have any extreme hardships or anything planned that would get in the way of you serving as a juror?
No.
You heard earlier that the state is seeking the death penalty in this case, which makes it an unusual process and different than most trials. Do you have any personal or moral or religious opposition to the death penalty?
No.
Now, some people have thought a lot about it. Some people have thought very little about it. Some people have very heated opinions. Other people are more middle of the road. There's some people that would say anytime the state goes forward on a first-degree murder charge, they should seek the death penalty. Other people would say, no, they should never seek the death penalty. We shouldn't even have the death penalty. No matter what someone does, they should not be put to death. And then we have people that are more in the middle, that they would say, it really depends on the case. It really depends on the circumstances. I'd have to hear the evidence before being able to make a decision. Where would you say you fall on that spectrum?
Middle of the road.
All right. And after we get through that guilt phase where the state proves the charges, if you and the other jurors believe the state proved at least one count of first-degree murder beyond a reasonable doubt, you'll be asked to come back to that penalty phase. And at that penalty phase, the state will have to prove aggravating factors. And the law is very clear that just because we go forward on a first-degree murder, there are certain qualifications, certain things that have to be present for us to seek the death penalty. We have listed those factors that we believe we can prove, and you'll hear about those later on in the process. Now, if you find, and the rest of the jurors find, that we prove one of those factors beyond a reasonable doubt, the defense will also have the opportunity to present any kind of mitigation, and they can do and present whatever they want with regard to why their client should not get the death penalty. You'll listen to all of that. You can consider evidence you've heard during the trial, during the guilt phase, and then it will be up to you and each individual juror to make a recommendation. And there will have to be at least 8 jurors that agree to recommend death, and anything less than that would be a life sentence, but it's up to the jurors to make that recommendation. recommendation. Do you believe that you'd be able to, if you felt the circumstances rose to a death penalty sentence, that you'd be able to sign your name and make that recommendation?
Yes.
And then on the flip side, do you believe that if the circumstances really didn't seem like a death penalty type case, or they didn't seem warranted for someone to be put to death, that you'd be able to make a life recommendation?
Yes.
Obviously, this is a very big ask. It's a huge responsibility. It's not a decision. Probably most people wake up and think, I'd like to have to make that kind of decision. But because it is a state of the law in Florida, we are here today based on what the state is alleging happened in this case. And you believe that you would be able to make this kind of decision?
Yes, I do.
Thank you very much for your time.
Good morning.
Good morning.
My name is Kevin Shirley. Mr. Hollander is my co-counsel, and it's our privilege to represent Mr. Wilson here today. Let me just ask a couple of questions. I think you can gain from what we're talking about that if somebody's convicted of first-degree murder in the state of Florida, there's one of only two possible penalties. You've either got the death penalty or you've got life in prison. You understand?
Yes.
Life in prison in the state of Florida is a little different than it used to be, because it used to be they had a system of parole where if you were a good inmate and you did lots of wonderful things, they would consider letting you out early. They did away with that. I don't know if you're aware of that, but
Not aware, but
okay. Now, if you sit as a juror and you recommend that Mr. Wilson be sentenced to life, he would literally spend every day of the rest of his life in prison. He could not be released from prison for any reason. Do you understand? Do you think that's a serious sanction?
yes, I think it's warranted depending on the crime.
Okay. The death penalty, would you agree with me, should be saved for those exceptional homicide cases, not just for every homicide case?
Depending on what you mean by exceptional. Yes, I would agree.
All right. Well, and in order to show that, there are the state would have to prove certain aggravating factors, things that make it sound even worse than it did during the trial. You understand? They may use facts that came out during the trial, but they want to emphasize why this is one of those exceptional circumstances. Do you understand?
I think so.
Now, the burden on the state of Florida for these aggravating factors is beyond and to the exclusion of every reasonable doubt. It's an extremely high burden of proof. It's the same burden that they had in order to convict Mr. Wilson in the first place. You understand?
Mhm.
Is that a yes?
Yes, I'm
We got a
sorry.
microphone
I'm
there.
sorry.
It's fine. So if the state proves these aggravating factors, and there's just a few of them, beyond every reasonable doubt to you, then the jury has to sit and decide whether or not they've proven it to all 12 people in the jury. Do you understand?
Yes.
And there could be one person on that jury that says, I'm not convinced. And that one person carries the day for the whole jury panel at that point in time, and the jury has to recommend life. Do you understand that?
Yes, I understand.
Okay. And can you adhere to that?
Yes.
If the jury as a whole finds that there's been an aggravating factor proven beyond every reasonable doubt, then you have to consider mitigating circumstances, things that would lessen the severity of the charge. So it stays at first-degree murder, but the aggravating factors can be mitigated down to the point where the mitigating circumstances are more important in your mind than the aggravating factors were. Do you understand?
I think so.
And do you think that that's possible, that you could consider other evidence in this case in order to mitigate the aggravating factors?
Depending on the evidence, yes.
Okay. Now, the mitigating circumstances where the aggravating factors, there's only a few mitigating circumstances. The judge may read you a list of mitigating circumstances that you consider. You can consider them or not consider them. But you're not tied to that list like you are aggravating factors. Other things may be running around in your head, evidence that you heard during the trial. There might be testimony of witnesses on behalf of Mr. Wilson. They may come in and testify about Mr. Wilson's childhood. There might be mental health people who come in and tell you things about Mr. Wilson's mental health. And would you be able to consider those as mitigating factors?
Possibly, yes.
All right. I'm not saying automatically, but obviously, if there were an expert that came in and testified, you would consider the testimony of the expert and judge the expert's credibility and the like. I just want to make sure that you're open to that.
Yes.
You are. Okay. Then if you determine that the mitigating circumstances outweigh the aggravating factors, then at that point in time, you have to recommend life in prison because the aggravating factors have been mitigated. Do you understand that?
I understand what you're saying.
All right. Finally, if the aggravating factors outweigh the mitigating circumstances, you as a member of a 12-person jury go back and deliberate, and you have to vote on what recommendation you want to send to the judge by the jury as a whole. And in the state of Florida, there has to be 8 people that recommend death before the judge can impose the death penalty. Do you understand that?
I understand that.
Let's say there's 5 people that are voting for death and 4 for life, and it comes down to your decision. And your decision could carry the day. I mean, if your decision is for life, the majority up there wants death, but your decision is for life, and your decision is going to help carry the day. Can you do that?
I can do that on either side.
Thank you.
No objection.
No objection.
All right. So remember my earlier instructions. Please don't do any research, look up anything about this case, discuss anything about this case with anyone. And don't watch local news media, read any local newspapers. And then we'll have you return tomorrow morning at 9 a.m. at the jury room on the 2nd floor. Okay? All right. And then the bailiff will escort you out. We'll see you tomorrow morning.
Okay.
Thank you.
Thank you.
All right. 193. Lights on. It's on. Yeah. Oh, wait 1 second. Hold on. Wait. All right. Please have a seat. Are you juror 193?
Yes.
All right. Well, the attorneys to begin their inquiry.
Morning. How are you? I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Have you heard anything about this case prior to coming today?
Yes. From the news, I remember seeing it on the news maybe about a year and a half ago. And I did recently see it as recent as, I believe it was Friday morning of last week on Wink News.
Okay.
And that's about the only time that
All
I
right.
heard of it.
Now, it's okay if jurors have seen things about this case or heard things about it. What we're asking, though, is are you able to put aside what you may have heard or seen and decide this case based on the evidence presented in this courtroom?
Yes, ma'am.
And so we plan on, during the guilt phase, to prove the charges beyond a reasonable doubt, where we will call witnesses, where we will present evidence, and we will ask you at the end of the presentation of the case to make a decision as to whether the defendant's guilty or not. So you believe you can do that regardless of what you've seen or heard?
Yes.
Now, you heard that this trial is supposed to be 2 to 3 weeks. We anticipate it'll be another 2 weeks after this week is concluded. Do you have any extreme hardship that will cause you to be unable to sit on this jury?
No, not at all. I'm semi-retired.
Okay, all right, thank you. Now, unlike most trials, the state is seeking the death penalty in this case. Do you have any personal or moral or religious opposition to the death penalty?
I do not.
Now, some people, when it comes to the death penalty, have very strong opinions either way. Some people are more in the middle. You have one extreme where people say if the state charges first-degree murder, then that person should automatically get the death penalty, no matter what the facts, no matter what the circumstances. And then you have people on the other side that say the state should never seek the death penalty. We shouldn't even have it. It doesn't matter how egregious the case is. There should not be the death penalty. And then you have people in the middle that say you should look at each case. There should be, it's a case-by-case basis. It depends on what the facts, it depends on what the circumstances are as to whether there should be death involved. Where would you say you fall in that
I
spectrum?
fall right in the middle of that.
Okay. And the state of Florida actually does require the state to allege certain aggravators. The state can't just seek the death penalty unless there's those factors. Now, after the guilt phase, if you and the other jurors have decided the state proved at least one count beyond a reasonable doubt of first-degree murder, you'll go on to that guilt phase where the state will have to present those aggravators to you. You, again, will have to find at least one of those aggravators that we've proven beyond a reasonable doubt. Now, the defense has the opportunity to present mitigation. They can present mitigating circumstances as to why they don't believe their client should get the death penalty. Do you think you'd be able to sit and to consider all the evidence, to consider everything you hear and make a recommendation?
Yes, I can. That would take all of the information that's presented in it to make such a sound and precise decision based on it, based on all the facts that are presented, the overall scope of all of the evidence and everything that's been proven.
Yes.
Would make, the decision for that.
Right. And that's all we ask, because we ask that you listen to everything. And at the end of the day, each juror gets to make their own recommendation. Each juror has to see what the evidence shows, see what's presented, and make a determination as to what sentence they think is appropriate. Typically in a trial, jurors don't have anything to do with the sentence, but in a death penalty case, it's unique and that you make a recommendation. Now, there has to be at least 8 jurors to even recommend death. If there's not 8 jurors, then the defendant automatically gets a life sentence. So you might be someone that there might be, let's say there's 7 people that recommend death and you're that deciding vote. Do you think that if you felt that the death penalty was appropriate, that you'd be able to sign your name and be that 8th person recommending death to the judge?
Yes.
Now, on the flip side, if there are 7 people that say, I think it should be life, I don't think the facts and circumstances really rise to a death sentence, would you be able to be that person that would make it a life sentence, that would say, I recommend life, I think that's appropriate?
I would not argue that, because the fact, looking beyond the decision of life or death, I look at it in a way that this individual should never be anywhere among society, whether he's on this earth or not,
Right.
to harm or put anybody at risk.
So in Florida, life is life. There, we no longer have parole. They don't have the ability to get out of prison. It's either life or death. Those are the only 2 options in this case. Knowing that, if you felt the state hadn't proven there was enough for the death penalty, would you feel comfortable saying, I would recommend life, given what I've heard? I just don't think there's enough. Maybe there was mitigation presented that you felt sort of mitigated a death sentence. Would you be able to make that recommendation of life?
It has to be going over all of the facts of the case. I could do life on it, because I don't stand where it's the death sentence only, and I can, with all of the facts and the balance in between both,
Yes.
is where and going over that with the rest of the jury would come to the agreement based on everything that's been presented to make a sound decision on that.
So because you are in the middle as to death penalty and you are in that sort of neutral area, you believe, you haven't come in here today and said, definitely he gets the death penalty. You're in here and you're going to listen to the facts and you're going to listen to the evidence and make your own decision based on what you hear.
That is correct.
All right. Thank you very much.
Wait 1 second. I'm gonna, if you'll have, I'm gonna let Mr. Shirley ask some questions.
Morning. My name is Kevin Shirley. I am co-counsel with Mr. Lee Hollander, and we represent Mr. Wilson in this case. Okay. I just want to make sure I understand. You wouldn't hesitate to recommend life in prison as a possible penalty for conviction of first-degree murder. Is that correct?
I wouldn't hesitate to it. No, I would, if it were life without parole, absolutely. Looking at the facts that will be presented in this case and all of the evidence to back up and prove beyond a reasonable doubt of what has happened or transpired would make my decision of what I would want to do, whether it would cross life in prison to the death penalty. And that would be based on the facts that are presented to me.
Okay. Well, what we want to do is we want to make sure that it's not just the facts that are presented to you at trial. Obviously, if you return a verdict of guilty to at least 1 count of first-degree murder, you've already made a decision that beyond every reasonable doubt, the state has proven its case for first-degree murder. So you already have those facts at your disposal, and you can't just wipe them out of your memory because you just sat there for 3 or 4 days listening to people testify and looking at photographs and listening to experts and the like. So you're going to take that knowledge and that experience in with you to the jury room. But just because he's convicted of first-degree murder doesn't mean he's automatically eligible for the death penalty. Do you understand?
Yes.
So now the facts and circumstances during the case may assist you in determining whether or not the state has met its burden of proof of showing why this isn't just, I hate to say this, a run-of-the-mill, a regular homicide. None of them are regular, but it's not just a homicide like you see every day on the news. This one is exceptional. They have to prove aggravating factors to show that this is exceptional. They might use some of the facts from the trial, but they have to use argument and everything else to rise to the higher level to show that this is an exceptional case. Do you understand?
Yes.
Now, the difference here, though, is the defense has the opportunity to argue and to present evidence of what they call mitigating circumstances, that, well, this was a terrible homicide and it rose to this level. However, the defense, after showing mitigating circumstance, brings that aggravator down. You know, it's almost like putting salve on a wound or something. The wound is terrible and it's blistered and it hurts, but you put the salve on it and all of a sudden it goes away. Do you understand?
Yes.
Okay. Now, amongst those mitigating circumstances, the judge is going to give you a list, but you're not confined to that list. You can listen to anything. You might be able to use something from the trial that you heard that goes, oh, well, you know what? I think that's a mitigating circumstance. You can entertain testimony from witnesses. Mental health experts can come in and testify. People can come in and testify about Mr. Wilson's childhood. All kinds of things can come to your attention that are mitigating circumstances. Do you understand?
Yes.
And those mitigating circumstances may rise to the level where all of a sudden the aggravating factors aren't nearly as bad as you thought they were in the first place in light of the mitigating circumstances, in which case now, if the mitigators outweigh the aggravators, you have to come back with a recommendation of life. But that's your individual decision. Do you know? Do you understand?
Yes, I do.
And when you go back to the jury room, and you're going to come back with a recommendation as to what the entire jury panel's recommendation is going to be to the judge. You get to vote, but it's not the same kind of vote that you had when you went back to decide whether or not he was guilty or not guilty. This is a highly individualistic vote. It's based on your life experiences, your views of the case, the evidence you've heard, but it's more than just the evidence. It's you as a person and what's made you the way you are now. Is this the kind of case that I can get up there and say, judge, sentence him to death? Okay. You don't have to agree with anybody. All you have to do is give your verdict, the verdict that you individually that you can live with. You understand that?
Yes, I do.
Okay. I don't have any further questions.
All right. All right. So remember my instructions about not doing any research, looking up anything, or discussing anything about this case with anyone. You remember that?
Yes.
Okay. Can you follow those instructions?
Yes.
Also, do not watch any local news media, read any local papers, look at anything like that, or look up anything on the internet. Can you do that?
I can.
All right. Then we will have you come back tomorrow morning at 9 a.m. in the jury room down on the second floor.
All righty.
Thank you.
Thank you,
Okay,
Your
I'll
Honor.
escort you out. All right. Please be seated. And are you juror 362? All right. I'll allow the attorneys to begin their inquiry.
Good afternoon.
Sit, stand.
Yeah, you can please.
Oh, I'm sorry. Yeah, please be seated. You're okay.
I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in today, had you heard anything about the case?
No, ma'am.
And you heard that the length of trial is 2 to 3 weeks. We were already in our first week, so we anticipate another 2 weeks. Do you have any extreme hardships or reasons why you would not be able to serve over the next several weeks?
Possibly work. I'm not sure if I get paid for this.
Okay. Where do you work?
Allied Property Group. I'm a property manager.
All right. Is that something that you could check into if you came back tomorrow and just see if you'd be able to get paid?
I can. It would also create a hardship on all my properties because there's no one to cover
Okay.
any of my shifts.
All right. So if you were out of work for the next 2 weeks, would you have difficulty giving your undivided attention to this trial?
Yes.
All right. Thank you very much.
All right. Your jury service is complete for the year. You are excused.
Okay. Thank you very much.
You're welcome.
No objection.
Okay. No objection for 362 being stricken for cause. So let me just, for planning purposes, I know we're into the lunch hour. If we stop now, then we have 10.
Stop after this next 4.
So finish this group. Okay. All right. Then let's do that. Next one, 223. Right?
Yeah.
All right. Mr. Shirley can let me know when I need to stop.
And I will do it. Mr. Hollander and I have other considerations. We could expire at any point in time. Oh, we promised that wouldn't happen.
You're aware of some of the situations we've had in this courtroom in the past couple of years. That it happens to my mom in church. It's all right. Just please put it on silent.
As long as it's while everybody's singing, it doesn't make any difference. Juror entering.
All right. Please be seated. Are you juror 223?
I am, sir.
All right, then I'll allow the attorneys to begin their inquiry.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state of Florida. Prior to coming in this morning, had you heard anything about the case? Is that it?
Oh, no,
Thank you. The court reporter has to type everything, so.
I just,
Now, the judge mentioned that this trial will be 2 to 3 weeks. It will probably be an additional 2 weeks after this week. Do you have any extreme hardships or anything that will cause you to be unable to serve?
No.
Now, you heard this morning that the state has filed a notice of intent to seek death in this case. That's a very unusual thing, and so it necessitates a two-part process. Typically, jurors don't get a say in what happens in a sentence, but in this case, the jurors are actually required to make a recommendation of either life or death. Do you have any personal or moral or religious opposition to the death penalty?
no.
Now, some people have very strong opinions, and some people are more middle of the road or just haven't really thought about it at all. There's some people that would say anytime the state seeks first-degree murder, that there should be death. That doesn't matter what the case is, doesn't matter what the circumstances are, they should automatically get death. Then there's people on the other end of that would say we shouldn't have the death penalty. Even for egregious cases, even if multiple people are killed, we should not have it. It should be outlawed. Then we have people in the middle that would say it really depends on the case, that not every murder is worthy of the death penalty, and that some murders are worthy of the death penalty, and they would really have to hear on a case-by-case basis and hear the facts of the case. Where would you say you fall on that spectrum?
I would say I'm middle to this side where, a death for a death.
Okay, so you're
Sorry, I didn't hear the last part. Middle to what?
Like a death for a death, like I would lean towards, but I would, of course, consider all circumstances.
so just because you might lean more toward death, what make you automatically recommend death in this case?
Correct, it would not automatically.
So you would sit and listen to the evidence. And that's what we're asking you to do. So the first part will be the guilt phase, where it'll be our burden to prove the charges beyond a reasonable doubt. And if we prove at least one count of first-degree murder beyond a reasonable doubt, then you and the jurors will come back for that penalty phase. And at the penalty phase, the state will have to present aggravators, and will have to prove at least one of those beyond a reasonable doubt. And the state of Florida is not allowed to seek the death for any reason. We have to have specific aggravators laid out in the statute. And so you'll listen to the evidence, and we'll present what we have as far as aggravators, and the defense has the opportunity to present mitigating circumstances. So if there are things that they believe would mitigate the death penalty and would necessitate a life sentence, they can present that. And at the end of the day, it'll be each individual juror's choice as whether to recommend death or recommend life. Now, 8 jurors, there has to be at least 8 jurors recommending death for the defendant to get the death sentence. If there's not 8 jurors that make that recommendation, then he'll get life. And life is life. It means no parole. He would serve day for day. Now, knowing all of that, if it came down to it and you felt the facts were really strong, that they did rise to the level of a death penalty sentence, would you feel comfortable making that recommendation of death?
Most likely, yes.
All right. And it'd be hard to do. I mean, it's not something that would be easy for anybody. It's not a decision that I would hope anybody would take lightly. On the flip side, if you heard the evidence and you felt that the facts were not egregious or the facts did not rise to that level of death, would you be able to recommend a life sentence in that situation?
If they were not egregious.
Yeah, so
was the question.
Well, let me rephrase that. So it'll be up to you to decide whether you think the evidence points toward a death sentence or whether it points toward a life sentence. And you as a juror can really consider all the evidence that you hear. You can consider the mitigators the defense presents. You can consider the testimony from the trial. You can consider all those things in deciding what your recommendation is. So would you feel comfortable after hearing the evidence of making that decision? And that decision might be death based on how you feel about the evidence. It might be life based on how you feel about the evidence. But would you feel comfortable making that decision of either life or death?
I can't say I would feel comfortable,
Okay.
but I would proceed to the I would do the right thing regardless of my discomfort about it.
And that's a much better way to phrase it, because I think nothing about this process is comfortable. And so that's really not an appropriate word. I think how you said it is perfectly stated, that you would be able to follow the law and be able to do your job as a juror. Thank you very much.
Mr. Shirley.
Thank you. Good afternoon. My name is Kevin Shirley. My co-counsel Lee Hollander and I represent Mr. Wilson.
Hi, Kevin.
Let me start with something that you said. You said that you would be somewhere between the middle and death penalty, and then you said a death for a death.
Yes, sir.
Okay. Let me remind you that the judge read you an indictment earlier today, and the indictment informed you that there were 2 young women that were killed. One was killed allegedly by strangulation, the other by strangulation and or blunt force trauma. Okay. With that in mind, how far toward death are you leaning without hearing any other evidence in the case?
How far leaning? Do you want to give me like a spectrum of a choice on that?
Well, once you, what I'm trying to determine is you understand that the death penalty is only for those exceptional cases. If you're already leaning toward death because this is just a homicide case at this point, and you haven't heard any of the facts and circumstances, that's concerning. But armed with the fact that it's two young ladies and how they may have been killed, how are you more or less inclined for the death penalty?
I think it's determined on a case by case basis
Well-
after you hear.
Well, that's what I understand that, and you told us that, but you also said a death for a death,
Yes, I
which makes it sound like if it's
think if someone is guilty of the death of another innocent person, I think a death penalty feels appropriate overall, I would say.
could you consider a life sentence?
Most likely, yes.
Okay, most likely yes.
Yeah, I mean, it really, you just have to hear the situation to start to formulate those kind of ideas.
I'm going to need you to speak up a little bit louder for me. Sorry.
You
Oh.
would need to hear the circumstances to begin to formulate those ideas. There are, as you've said, mitigating circumstances if someone was mentally ill, or what kind of circumstances were present for that human at the time that that crime was committed.
That was my next area. If you're selected as a juror, would you consider mitigating circumstances like somebody's mental health?
I think that's necessary to do.
Okay. So if we didn't present any mental health evidence, would you consider anything else as mitigation?
You have to give me examples.
Well, like maybe something about the history of Mr. Wilson, his childhood, things that may have impacted him to resulted in the way that he is now.
And consider it in what sense?
Well, that's how you would have to deal with it. I can't tell you how to consider it because that's your own individual choice as to how you consider it. I mean, we could talk about that in closing.
I'm just wanting to get clarity about your question. Would I be considering that in relationship to the sentence or in relationship to the guilt of the crime?
Just the sentence.
Just the sentence.
Not the guilt.
Okay. Then yes, in relationship to the sentence. Yes, sir.
You would consider. Okay. Do you understand in the state of Florida, life is life. There's no parole anymore. If you recommend he be sentenced to life, he gets locked behind the doors and none of us ever sees him again. He doesn't ever come out. You understand that?
I understand you're saying that, and I believe you, obviously. Is that law more recent in the last 20 years?
Yes, they've changed the law. We had a system that allowed for parole.
Right.
If you maintained yourself appropriately and maybe did certain things, advanced your education, things like that while you were in prison, you didn't have disciplinary reports and things like that, then you were eligible for parole and you could be released early. We don't have that anymore. When you go in, we don't ever see you again. You understand that?
Yes.
Does that change your mind at all about whether or not you could impose life as opposed to death?
It is comforting to know that that is the law now.
Okay. Does that make it easier for you to consider life?
Yes.
Okay. I don't have any further questions. Thank you.
Okay.
Okay.
All right. So remember my earlier instructions about not doing any research, looking up anything, or discussing anything about this case with anyone. Remember those instructions?
Yes, sir.
Okay. Can you follow those instructions?
Yes. Yes. I can.
So going forward, in other words, don't watch any local news media, don't read any local papers, and don't discuss anything about this case with anyone. Now, your name sounds familiar to me. Do we know each other?
Perhaps we do.
Okay. How would that be?
I think do you have a father that's Judge Thompson?
Yes.
I think
Yes.
that my family knows your parents.
Yes.
Yes.
That's what I thought. So just for full disclosure, if anybody had questions about that.
I'll just ask quickly.
Okay.
Knowing having family that knows his father, he's obviously a neutral party to this. Will that weigh in your decision making at all with this case?
I would suspect not. But I would like to say, because my husband told me at jury hearings that they ask you about your profession and your
Yes.
family's profession?
Yeah, we will do that. So tomorrow, when we have the general voir dire, when we bring everybody back, we'll go through that type of background. This portion is just to see if you qualify, if feelings about the death penalty and your time availability and news media. Tomorrow we'll address all those professions. Do you have a profession that makes you believe you could not sit on this type of case?
My husband said sort of that might be the case, yes, for
Okay,
him and I both.
All right, what are your professions? Is it okay if I ask you?
Yeah, that's fine.
Yes, my husband is an attorney.
Okay.
And I am a clinical social worker. I have worked, I interned in the Department of Justice when I was younger.
Okay. What type of attorney is your husband?
He is a business and tax lawyer.
Right. So that doesn't in any way make you unable to serve. We have sometimes we have lawyers on our panel. But anything about you serving as a social worker or your husband being an attorney that would make it so that you're unable to be fair and impartial and listen to this case?
I guess not. I mean,
All right. Thank you. Thank you for letting us know that.
I will also disclose that I believe that they assisted my parents with growing and cultivating roses and did a very good job.
when I was a young girl, yes.
Any other questions from State or Defense? Okay. All right, then. So I'll ask you to remember and follow my instructions and come back tomorrow morning at 9 a.m. to the jury room on the second floor. But remember, you can't discuss this case with anyone, not even close family members. Okay.
I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state. Prior to coming in here today, had you heard anything about this case? Now, you heard the judge say that the length of trial is between 2 to 3 weeks. We anticipate another 2 weeks after this this week is concluded. Do you have any extreme hardships or reasons why you would be unable to serve as a juror?
Just usually like work. I'm a server, so like I make my money, day to day. That's probably the only thing. And then I take care of my aunt at home. That's
Okay.
mainly just about it.
All right. Now, as far as your serving, is that mostly on nights and weekends, or do you do the day shift also?
Day shift, like all day.
Okay. Where do you serve?
Captain Hooks and Cape Coral.
Okay. And then you said you take care of your aunt. Is there anybody else that can care for her?
Usually not really, no.
And does she need full-time care? So based on that, would it be difficult for you to serve on this jury and give your full attention? And that's a yes.
Yeah.
All right. Thank you.
No questions.
All right, sir. So your jury service for the year is complete and you are excused.
Thank you.
$27. No objection to 377 stricken for cause.
Sure entrance.
All right, please be seated. All right, are you juror 27?
Yep.
I'll allow the attorneys to begin their inquiry.
Good afternoon. How are you?
Good for you.
I'm Sarah Miller, and this is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in here this morning, had you heard anything about the case?
No.
Now, you heard that the trial is going to be 2 to 3 weeks, probably an additional 2 weeks after this one. Do you have any extreme hardship or reasons you cannot serve?
No, I run an insurance brokerage, but we can fill in. So.
All right. Thank you very much. Now, unlike most trials, the state has is seeking the death penalty in this case. So that changes how this process goes. Normally, jurors don't have any kind of say in the sentence. But in this case, you will be required to make a recommendation if the state proves at least one count of first-degree murder beyond a reasonable doubt. Do you have any moral or any religious or just personal opposition to the death penalty?
No, I don't think I have a strong feeling towards either. I don't have any religious tendencies, so morally, I think it's something that can be used as a last resort.
So would you say if you have one side of the spectrum where people think it should always be used no matter what kind of murder it is, and you have the other side that would say we should never have it, would you say you fall somewhere in the middle, or would you?
Middle to lower.
Okay.
Yeah.
So middle to maybe leaning toward not seeking it. Now,
Is that yes? I know.
Yes.
Okay,
yes,
sorry.
yes, yeah, sorry.
everything's being typed. So now, the state is, in order to seek the death penalty, we have to allege certain aggravators that are listed out in the statute. And then it will be our burden to prove one of those aggravators beyond a reasonable doubt at that penalty phase. The defense will have the opportunity to present mitigating factors, circumstances, and they can be a multitude of different things. And you'll get to consider everything as a juror. You'll get to consider the facts from the case, from the guilt phase, as well as anything presented at that penalty phase. And it will be up to you to make a recommendation. If 8 of the 12 people recommend death, then that's the recommendation to the judge. If it's less than 8 people, then it's a life sentence. Do you believe that you would be able to make up your own mind to listen to the evidence evidence, and if the evidence required a recommendation of death, would you be able to make that recommendation?
Yeah.
And then vice versa, you'd be able to make that recommendation of life as well.
Yeah.
Right. And so would you be able to agree to weigh those aggravating factors and mitigating circumstances with an open mind and determine whether death or life imprisonment would be appropriate in this case?
Yes.
All right. Thank you very much for your time.
All right, Mr. Shirley.
Thank you. Good afternoon.
Afternoon.
My name is Kevin Shirley. That is Mr. Lee Hollander. He and I are co-counsel for Mr. Wilson. Just a couple of quick things. I'll change my pattern here a little bit. You understand that there's only two possible penalties for a conviction of first-degree murder, that being death penalty. Prosecutors talked to you about that. And the other is life in prison. State of Florida, I can't even talk anymore. State of Florida has changed the law here within the last dozen years or so. We used to have parole, where if you were a good inmate, advanced your education, didn't get in any trouble, they would consider allowing you to leave early. State of Florida doesn't have that anymore. If you as a juror recommend that Mr. Wilson get life as the sentence in the case, Mr. Wilson will go to prison, they'll shut the doors, and we'll never see him again because he will not be permitted to get out into society.
Mm-hmm.
He will be there the rest of his life. Do you understand that?
I understand.
Do you think that's a pretty serious sanction?
Yeah.
And do you think that's an appropriate sanction?
Yes.
You mentioned you are on the spectrum, you're trying in the middle to maybe not on the death penalty recommendation. Nevertheless, would you at least consider death as a possible penalty if, in fact, the state can meet its burden of proof in the case?
Yes.
Okay. And as the prosecutor has alluded to, they have to prove aggravating factors beyond every reasonable doubt. The judge will give you a very small set of aggravating factors. You can't include anything as an aggravating factor. It has to plug into one of those categories. Do you understand?
Yes.
If in fact they don't prove it to each and every one of the 12 jurors initially, and there might be one juror who says, no, I don't see any aggravators, then you guys are done and it's a life recommendation.
Okay.
Okay. Now, if you get past that point and everybody sees, well, there's at least one aggravator here, then in that event, you go on to determine whether there are any mitigating circumstances. And we call them circumstances because we don't have to prove those beyond every reasonable doubt. It's only a greater weight of the evidence.
Okay.
All right. And among those mitigating circumstances are such that the judge may give you a list of those, but unlike aggravators, you're not confined to that list. You can draw upon your life experience as a human being to determine in your own mind what might cause you to lessen the impact of the aggravating factors.
Mm-hmm.
That might be something that you heard during the trial. It might be information that you obtained during the penalty phase, something about Mr. Wilson's childhood, something about mental health. You can use any of those things that you feel mitigate the impact of the aggravating factors. And then you decide whether or not the mitigating circumstances have outweighed the aggravating factors. If they have, then you recommend life.
Mm-hmm.
You understand? Mm-hmm. If they don't, then you're going to have to go back and you're going to have a vote. And in the state of Florida, that requires 8 out of 12 people to vote for death in order to recommend death. But you've already told us that you'll keep an open mind with the understanding that both life and death are potential penalties in this particular case.
Yeah, the only outcome is if found guilty.
Okay. I don't have any further questions. Okay.
All right, sir. You remember my earlier instructions about not doing any research, looking up anything, watching local news media, or reading any local papers? Can you follow all those instructions?
Yes, I can.
Also, not talking about this case with anyone,
Yep.
okay?
Mhm.
All right, I ask you to follow those instructions and come back tomorrow morning at 9 a.m. in the second floor jury room.
Okay. Thank you.
All right, and 141.
Your entrance.
Right behind the microphone. Thank you. All right, please be seated. All right, are you juror 141?
Yes, I am.
All right, I'll allow the attorneys to begin their inquiry.
Good afternoon. You were the last person in the jury room just
Yes,
a
I
moment ago. We don't do that on purpose. So I'm Sarah Miller. This is Andreas Gardner. We're both here on behalf of the state of Florida. Prior to coming in today, had you heard anything about this case?
No, I have not.
And you heard the length of the trial. It's expected to be another 2 weeks. Based on that, do you have any extreme hardships or situations that would cause you to be unable to serve?
It might be difficult as far as my work is concerned because I'm the only one that performs my tasks of my job.
Where do you work?
Sun Harvest Citrus. I'm a
Oh.
bookkeeper. Yeah.
Ah, they have good
Juice.
ice cream. I like their
Yeah.
orange ice cream.
Hmm.
Would they be able to accommodate you if you were chosen to be on this jury?
I'm not sure because, like I said, I do the accounts payable,
All right.
and nobody else knows how to do that. So bills
Okay.
would not be able to be paid if I wasn't there.
All right. So based on that, would you have a hard time giving your undivided attention to this case if you were chosen as a juror?
I don't think so.
Okay. So even if you're chosen, you'd be able to still sit and listen to this case.
Mhm.
Just probably not
Is that
preferable to
yes?
your,
Yes, I'm sorry.
Okay.
probably not preferable to maybe Sun Harvest Citrus to have you here, but you would be able to do it.
Correct.
All right. Moving on to the fact that this is a death penalty case. Do you have any personal or moral or religious opposition to the death penalty?
No, I do not.
Now, some people have very strong opinions. Some people are more middle of the road. You have some people that would say anytime a murder is committed or a first degree murder is charged, that person should automatically get the death penalty. You have people on the other side that would say we shouldn't even have the death penalty. It doesn't matter what the crime, who's killed, what the facts are, we shouldn't have the death penalty. And then you have the people that are middle of the road that would say, I'd really have to hear the facts. I'd have to know what the allegations were. I'd have to hear everything before I could say and recommend either death or life. Where would you say on that spectrum you fall?
I would say I fall in the middle of the road.
Now, what will happen is if at the first phase, the guilt phase, the state will have to present evidence. Will present witness testimony. There will be evidence presented through physical evidence. And at the end of the case, we'll ask the jury to deliberate and to decide whether the state proved the charges beyond a reasonable doubt. If all of the jurors agree that we have proven at least one count of first degree murder, then that's when we'll go on to the penalty phase. And at that penalty phase, each juror will make a recommendation as to whether this case, there should be death or there should be life. And at that penalty phase, it's a very strict process for the state. There are only certain types of cases where we can seek the death penalty. There are aggravators that are laid out in the statute, and we have to list those aggravators ahead of time, and then we have to prove those to the jurors. And if we prove at least one aggravating factor beyond a reasonable doubt to you and the other jurors, then you have to consider what the proper recommendation is. And the defense will have the opportunity to present mitigating circumstances where they can say, well, there's all these things we'd ask you to consider that would make a life sentence appropriate. But at the end of the day, that's going to be up to you to consider what you may have heard at the trial, what you hear in the penalty phase, and to make that recommendation. Do you believe if after hearing everything, you believe that that evidence rises to the level of the death penalty, that you would be able to make that recommendation of death?
Yes, I do.
And then on the flip side, if you believe the evidence doesn't really rise to that, do you believe you'd be able to make the recommendation of life?
Yes.
Based on, obviously, this is a very serious responsibility. Do you believe you're up for being able to sit on this jury and to make a decision? Obviously, it's not fun. It's not a comfortable thing, but do you believe it's something that you'd be able to do?
I'm not sure. I feel very anxious even like right now. So I'm unsure about that.
All right. If called upon, though, and you were chosen, would you be able to follow the law?
Yes.
All right. Thank you.
Mr. Shirley?
Good afternoon.
Good afternoon.
Kevin Shirley, together with Lee Hollander, we represent Mr. Wade Wilson today. I just have a few questions. You said you wouldn't feel comfortable. You're in a catch-22. Well, let's see, do I put him in prison for the rest of his life, or do I recommend the death penalty? So it's kind of an unenviable position, no matter how you look at it, isn't it?
Yes.
Okay. Do you think you can do it?
Yes.
In the state of Florida, as we just discussed, one of the possible penalties is life in prison. State of Florida abolished parole many years ago. So regardless of Mr. Wilson's conduct in prison, if you recommend that Mr. Wilson go to prison, that's exactly where he goes, and he's there every day for the rest of his life. Do you understand that?
Yes.
He doesn't ever come out again. He's not in society again. He's in prison. Understand?
Yes.
Do you think that's an appropriate penalty in homicide cases?
Yes.
Okay. You understand that the other penalty, death penalty, is only for those exceptional cases? It's not for every homicide case.
Yes.
And it's for the worst of the worst. And the way we go about determining whether or not it qualifies is the state has to prove aggravating factors beyond every reasonable doubt. You understand?
Yes.
That's very high burden of proof. Whether you think it's fair or not, that's still the burden of proof on the state. And if they don't prove aggravating factors to the satisfaction of every one of the 12 jurors, then you have a duty to return a recommendation of life. Do you understand?
Yes.
Has to be all 12 of you. If the state does prove it to all 12 of you, then you move to the next stage where you have to consider mitigating circumstances. Among those mitigating circumstances may be things like something that you heard during the course of the trial that tends to lessen the impact of the aggravating factor. that didn't have anything to do with guilt or innocence, but it has to do with what you would consider on the penalty. Do you understand? In addition, we may elect to bring evidence for your consideration in the form of testimony. Mr. Wilson doesn't have to testify. You can't hold that against him, but we may have other witnesses in the case. Some people who may talk about Mr. Wilson's childhood, some people that may talk to you about Mr. Wilson's mental health, those kinds of things. Can you take those into consideration in determining what the appropriate penalty would be?
Yes.
Okay. And do you think if it get, now, once again, in the state of Florida, when you go back there to determine what the jury panel's recommendation is to the court, you guys have to come back with a vote of 8-4 for death in order for the judge to sentence him to death. Do you understand that?
Yes.
Are you willing to adhere to your position in the case, regardless of any pressure put on you by the other jurors?
Yes.
I don't have any further questions.
No objection.
No objection.
All right. So you remember my instructions about not doing any research, looking up anything, or discussing anything about this case with anyone.
Right.
Can you follow those instructions?
Yes.
Also, do not watch any local news media, read any local newspapers. Can you do that?
Yes.
Okay. Then we'll have you come back here tomorrow morning at 9 a.m. And be in the jury room on the second floor to meet first. Okay.
Okay.
All right. We'll see you then. All right. Please be seated. Are you juror 208?
Correct.
All right. Well, I'll allow the attorneys to begin their inquiry.
Good afternoon.
Good afternoon.
How are you?
Okay,
Is that the newest book? That
it is the newest book, yeah.
How is it?
So far, a few chapters of conversations we all had before the storm hit.
Okay, cool. I'm Sarah Miller. This is Andreas Gardner. We're both here on behalf of the state of Florida. Prior to coming in today, had you heard anything about this case?
I have been aware, yes.
And just from watching the news or through what source?
Local news.
Now, the state's burden is to prove the charges beyond a reasonable doubt through evidence alone that you would hear and see in the courtroom. We plan on calling witnesses, introducing physical evidence, and we're going to ask that the jurors base their verdicts solely on what's heard in this courtroom. Would you be able to put aside anything you may have seen on the news or heard about this case and base your verdict solely on what you hear in this courtroom?
It would be difficult because I do watch a lot of local news, so
Okay.
I'm familiar with everything. I try to be an independent person.
Sure. So you think it's something you could just listen to this evidence then?
I'd be open to that, yes.
Now, as far as the length of the trial, we expect this to go for an additional 2 weeks beyond this week. Do you have any extreme hardships that would cause you to be unable to serve?
I do have a hardship. Extreme is up to you, I suppose,
Sure.
and Your Honor. Was planning to go out of town on Friday. My wife's father passed away in the spring, and it would be long story short, that he got divorced. So the first half of the ashes were buried in one area. The second half of the ashes are being buried in New Jersey next to her mom.
And I assume there's other people involved in this.
That's correct, yes.
Okay. All right.
That's fine.
I have no objection.
Okay.
Thank you very much.
All right. Any questions?
Your Honor, thank you.
All right. Your jury service for the year is complete. You are excused.
Thank you, sir.
184. All right. 184. Yeah. And no objection to, I'm sorry, juror 208 being stricken for cause.
No.
All right.
I am. I'm not as old as his daddy, though.
I'm kind of old.
Huh?
I'm kind of old.
Sure entry.
All right. Please be seated. Are you juror 184?
Yes.
All right. I'll let the attorneys begin their inquiry.
Good afternoon. How are you today?
I'm good. How are you?
Good, thank you. I'm Sarah Miller, and this is Andreas Gardner, and we're both here representing the state of Florida. Before you came in today for your jury service, had you heard anything about this case?
No.
Now, the case is expected to be probably an additional 2 weeks beyond this week. Do you have anything in your schedule or any reason that you would be unable to serve over the next several weeks?
No, I'm free.
Okay. Now, moving on, as you heard the judge say that because the death penalty is involved, this trial will be in 2 parts. So the first part of the trial, the state will have to prove the charges beyond a reasonable doubt. And if we prove at least 1 count of first-degree murder beyond a reasonable doubt, then we'll go to the penalty phase. And in that penalty phase, the state again will have to prove an aggravator beyond a reasonable doubt. Do you have any personal or moral or religious opposition to the death penalty?
I'm on the fence with that one. I don't have any real opinions about it.
Okay, so let me ask it this way. There are some people that would say that any murder, we should be able to seek the death penalty. Regardless of what the facts are, regardless of who they kill or why they kill somebody, they should get the death penalty. Then there's people that would be on the opposite side of that would say we shouldn't even have the death penalty. And some states don't. The state of Florida shouldn't have the death penalty. And then there's people that are more in the middle, maybe people that haven't really thought about it or contemplated, but would say, I could follow the law and I would listen to the evidence and I would make a decision on a case-by-case basis. Do you believe you'd be in the middle or somewhere closer to not having the death penalty or having the death penalty?
I believe I'd be in the middle.
Okay. And so what we're going to ask is during that penalty phase, the state will have to prove, we've listed aggravators and given notice to the defense of certain factors that have to be present for the state to even seek the death penalty. We'll have to prove one of those beyond a reasonable doubt, and the defense can present any mitigating circumstances they have as to why they believe their client should not be given the death penalty. It will be up to you to decide whether you think, based on the facts and everything you hear, that it should be a life sentence or a death sentence. There has to be at least 8 people deciding that he should get death, or it's a life sentence automatically. Do you believe if the facts and circumstances rose to a level where you felt death was appropriate, that you would be able to make that recommendation?
It's something I've not thought about or dealt with, so I wouldn't be 100% sure.
Okay. Is there anything that you can think of as you sit here where you would just say, I couldn't do that. I would not, even if the facts and circumstances were what they were, I would never be able to sign my name and recommend death for somebody.
There's nothing that comes to mind.
And then the question on the flip side is if you believe that the facts and circumstances weren't egregious or didn't rise to a level where the death penalty would be appropriate, would you feel comfortable recommending life?
I don't understand the question.
So
I didn't hear your answer. I'm sorry, I couldn't hear your answer.
Oh, I said I don't understand the question.
Okay.
So the question is when you come down to the end of the trial, if he's been convicted, you've gotten the penalty phase, you've heard all the evidence, and the attorneys have made the arguments, and the state asks for a death sentence, and the defense asks for a life sentence. It will be up to you to decide which of those two you think appropriate. Do you believe that you can make either of those recommendations, depending on what you hear?
Yes, I believe so.
All right. Thank you very much for your time.
All right, Mr. Shirley.
Good afternoon. My name is Kevin Shirley. I, along with Mr. Lee Hollander, am representing Mr. Wilson here today. You seemed a little bit confused. I just want to make sure that you understand what we're talking about here. There are 2 possible penalties if you're convicted of first-degree murder, and only 2. It's not like the other lesser charges where there's a wide range of penalties that are available to the court. There's only 2. One is the death penalty, which obviously is serious. The other is life in prison. Do you understand?
Yes.
Okay. Life in prison in the state of Florida is different than it used to be. They used to have a thing called parole, where if you were a good inmate, you would serve your time. And if you did certain things and didn't get in trouble, they would consider letting you out early. Well, they don't do that anymore. They did away with parole. So if you're a juror and you recommend that Mr. Wilson go do life in prison, that's exactly what it means. He'll be in prison every day for the rest of his life. Do you understand that?
Yes, I do.
Would you agree with me that that's a pretty serious sanction also?
Yes.
That he never gets to come out again?
Yes, that is serious.
Okay. Now, if you're selected as a juror and you get to that point, if the jury finds Mr. Wilson guilty of at least one of the 2 homicides, there will be occasion for you to have to make a decision as to whether or not you're going to recommend death or you're going to recommend life in prison. And that's a multi-step process. The first step is for the state to convince you that this is one of those few homicide cases that's worthy of consideration for the death penalty. Because not all homicide cases are. Very few of them are worthy of consideration of the death penalty. Do you understand? Only the worst of the worst. And in order to determine if it fits into that category, you're going to be given instruction on some aggravating factors. Now, the state has to prove their aggravating factors beyond and to the exclusion of every reasonable doubt. If they don't convince all 12 of you of that, if maybe one person says, I'm not convinced that they have shown me even one aggravating factor, then you guys are done. And the recommendation is for life. Do you understand?
Yes.
You don't go on to the next stage. If for some reason all 12 of you vote that there is an aggravating factor, then you go to the next step where you consider mitigating circumstances. Those circumstances that tend to lower the impact of the aggravating factors. You understand?
Yes.
And amongst the circumstances that you might consider, the judge will probably read you a list of mitigating circumstances, but you're not confined to that list. You can consider something you heard during the course of the trial. You can consider testimony from potential witnesses. You can consider things like Mr. Wilson's childhood, if something traumatic happened in his childhood, his mental health issues, all those kinds of things you can take into consideration and to determine whether or not the mitigating circumstances outweigh the aggravating factors. And if they do, if the aggravating factors are mitigated, then you come back with a recommendation of life in prison. Do you understand?
Yes, I do.
If for whatever reason the aggravating factors still outweigh the mitigating circumstances, then you're going to come back and you're going to sit down with your fellow jurors and you're going to have to make a very, very serious individual decision as to what sentence you're going to recommend as a panel, as a jury, as a whole is going to recommend to the judge. Now, it takes 8 of you to recommend death in order for the entire jury panel to recommend death. Do you understand?
Yes.
Anything less than 8-4, and it's an automatic recommendation for life. Do you understand?
Yes, I do.
And do you think that you're capable of sitting there and making that decision as to which of those 2 very, very serious sentences that you would recommend that the judge impose on Mr. Wilson?
Yes.
I don't have any further questions.
No objection.
No objection.
All right. So you remember my earlier instructions about not doing any research, looking up anything, or discussing anything about this case with anyone. Do you remember that?
Yes, I do.
All right. Can you follow those instructions?
Yes.
You also follow the instruction not to watch local media, read any local newspapers, or do any internet research or anything about the case.
Yes, I can do that.
All right. And in terms of looking at media, like just don't look at it for now. Okay. All right. And then we will see you tomorrow morning at 9 a.m. in the jury room down on the 2nd floor. Okay.
All right.
All right. Thank you.